Yeah, so hi everyone. Good afternoon and welcome to the third webinar that the nasscom public policy team is hosting on the Data Protection Act. We have with us three experts that will be joining us today. We have Sreenidhi Srinivasan, who's a partner in the data protection practice at Ikigai Law. We have Vivek Sarkale, who's a director who works on data protection at EY. And we have Nitin Dhavate, who's joining us as a DPO for the Asia Pacific and Africa region from Novartis. So it's great to have everyone. Over to you, Ashish, to just lay down some context, and then we can move on to Sreenidhi's presentation.
Yeah, hi, thanks, Varun. So I think one of the big discussions for the global capability centers has been that, when they are looking at processing foreign data, there could be compliance issues with respect to our law and all of that. So a lot of that got sorted, hopefully, in the way the law itself is drafted. And specifically on cross-border data flows, there isn't a specific requirement which is already evident in terms of how the law is enacted. So some of that is ahead of us. Having said that, I think one of the big things for global capability centers is also the fact that we are large employers. So we discussed some of the context from an employment perspective in our previous webinar. The overall expectation, if I were to lay down for this webinar, is that we should be able to hear from experts and the industry to understand in the context of GCCs what is currently happening and what can be done today and what we should be doing today. And this is something that you can reconcile with your own work, and then feel free to connect with us after this webinar also, so that we can actually partner on this transition journey. So that's really the intention of this webinar, to get this conversation specifically in the context of the global capability centers going. And with that, I'll hand it back to Varun.
Yeah, great. So we're going to start with Sreenidhi's presentation, who's going to run us through the relevant provisions of the Act. I just request that everybody can raise questions for the open discussion section in the second half of the webinar in the quick Q&A box, and we'll be posing them to our experts as well. Over to you, Sreenidhi, and I'm going to stop sharing.
Thank you. Thank you so much, Varun. Thanks, Ashish, for having me here today. I'll just take a minute to share my screen. I hope this is clear. Great. Yeah. Hi, everyone. Thanks for tuning in. So over the next 10-15 minutes, like Varun and Ashish said, of course, there's a new data protection law in the country. And I think that there have been a couple of sessions before this on generally the basics of the law and different aspects of the law. Over the next 10-15 minutes, I'll just walk the room through the impact of this law on GCCs. I'll start with some very brief sort of overall impressions on the law and what the next few months are likely to look like in terms of compliance and preparation, and then focus on really two aspects which are critical to GCCs, which is who does the law apply to when you're a data fiduciary, data processor, what do all of these terms mean in the context of GCCs, and when does the law apply to you? So the situation or the scenario that Ashish laid out, which is, say, if you're a Indian entity which is processing data under an offshore contract with an offshore sort of data controller or a processor, then what might be the impact of that sort of situation on the if you're doing processing under that situation, what would that mean for you? So I think they're all sort of familiar with the journey of the law, right, on when this came about and all of that's happened. But where we are right now in this journey is that there is the law was enacted 2 months back, and the rulemaking process is underway right now. Where really just some quick overall impressions. Now, this is a comprehensive law which is looking to govern collection, use of personal data. And like most global privacy data protection laws, it is also principle based, which means that it doesn't specify very hard yeses and nos or do's and don'ts. Rather, it sets out principles, and then it is up to the business to determine what that principle means for its particular use case, for its particular activity. It, of course, represents a significant shift from the current legal framework, which is just the IT Act, SPDI rules, which are a set of rules under the IT Act which govern only sensitive personal data. Here, this is a comprehensive data law with a stringent sort of enforcement machinery, which is envisaged, so it represents a shift from that. Now, this enforcement machinery is in the form of a data protection board, which will be set up to enforce the law. It will award penalties. Penalties can go up to, say, 250 crore for failure to implement security measures and prevent data breaches. So it is sort of, an enforcing authority, which is, I'd say, more like the CCI than the RBI in that it's adjudicating and awarding penalties. And there are a bunch of implementation details that will be developed and which are expected to come through by the government in the form of rule making. Now, these rules will set out, say, for instance, what a notice should look like, how should you communicate with individuals whose data you've already collected under the old regime. So a lot of these implementation details, we're still waiting for rules to come out. And just for the benefit of the room, there was a consultation where the minister did indicate that the first priority is sort of setting up the DPB, some of the basic rules which are required to get the law up and running. Those will be published soon in the next month or two, and then sort of, implementation will roll out. So this is just the context very briefly on where we are at in the journey, and just digging into who is the law applying to. And I think this is sort of the starting point for any compliance exercise, and it is relevant equally to GCCs. There is the individuals at the center, and who are the individuals whose data is being collected. This could, of course, include user-facing platforms. This typically means your end users, end sort of customers. But for a lot of B2B enterprises, it also means your own employees, your own sort of any stakeholders, any vendors who might be sole proprietors, anyone that you're engaging, and whose personal data you're collecting. Any individual is a data principal. There is a data fiduciary on whom the entire force of the law is applicable. And the data fiduciary is really the entity, and the phrase is, they're calling the shots with respect to the data. They're determining the purpose and means. These are entities which are known as data controllers around the world, but we've called them fiduciary. But in effect, it's the same sort of understanding. They have control and discretion over how that data is to be used. There are data processors, who are entities which are only carrying out processing activities on behalf of the data fiduciary. Here, their job is limited to discharging whatever instructions and fulfilling instructions that the data fiduciary is giving them. There are significant data fiduciary entities. If you're processing large volumes of data, you might be designated as a significant data fiduciary. Now, I think for data fiduciaries, the idea is that this tag of fiduciary processor is not entity specific, it is activity specific. So you may be a fiduciary, you may be a processor in many situations when you're only processing your clients, or say, or if you're a GCC and it's sort of back office support functions to your global parent companies or parent company or any other subsidiary. In those situations, while you may be acting as a pure processor, in many other situations, you might be acting as a data fiduciary. So really the first step would be to understand what are those situations where you're acting as a data fiduciary in your own right. The obvious one is when you're processing your own employees' data, which is your employees are your own stakeholders, you're collecting using their data. And so the whole brunt of the law applies to you as a data fiduciary, and you have certain obligations towards the employees. In some situations, you might say be conducting R&D initiatives either by yourself or in collaboration with a global parent or with a global affiliate. In those situations, if you're calling the shots with respect to that data, how that research is to be conducted, in those situations, again, you're not simply acting on behalf of somebody, you're acting in your own right. If you're developing your own products, services, algorithms, if you're doing your own analytics, all of these situations, you're not simply, a data processor, which may be discharging some obligations, you're doing your own sort of data processing activity. So really the first step would be identifying what your role is for each distinct activity, each team, what is it that they're trying to do, where you're calling the shots with respect that you're carrying out. And a related but sort of critical piece is, when really does the law apply to you? So now the act applies to any processing within the territory of India. There is, this aspect of offshore processing as well, but I won't go in detail there. I think the baseline is just that if a processing activity is carried out in India, the law does apply to you. The law automatically applies to you. Of course, this is limited to digital personal data, which is in digital form currently, or non-digital data, which is also subsequently digitized. But as long as the processing happens within India, the law applies to you. There is an exception, and a critical one, which Ashish alluded to earlier. So, and what it says is, while the baseline is that if you're processing data in India, the law applies to you, but there are situations where you're processing data of data principals who are not within India, and you're doing this pursuant to a contract with any person outside India, and you're, of course, a person based in India. So 3 components here. One is that you're only processing data of data principals who are not within the territory of India, who are not situated within India. So Indian sort of IT BPM, you're processing employees, you're processing payrolls on behalf of your French headquarter company, all French residents. In that situation, you're not really, there's no Indian sort of data involved, is the logic. There's no Indian connection here, except for the fact that you're an Indian entity, India-based entity, but the data itself doesn't belong to individuals or doesn't relate to individuals who are within India. The second requirement is that you're doing this under a contract between you and that offshore entity. That's all that the law requires. It only simply says it's a contract, which means all of your standard legal requirements of offer, acceptance, you negotiate some terms, you sign the dotted line, and that's sort of a contract. But what that might mean is, well, while there are no other guardrails around what that contract should look like, at least at the baseline, you must sort of evaluate what your existing contracts look like with sort of the entities that you are processing this data, who you're processing data for. So, and of course, you're carrying out the processing at your own end. So I think that's the example that we'd also put out. If it's in back office support and you're only, all of those 3 conditions then get met if you're doing this pursuant to a contract, and that contract is also reflecting the requirements. It's kind of earmarking that these are my roles, these are my responsibilities, these are your responsibilities, here are some reps and warranties standard typically found in agreements. That's what this is trying to cover, that if this is the situation that you're operating under, then certain provisions of the law don't apply. It is a fairly wide exemption, but it is also not a blanket exception. In what that means is that the law doesn't say that in these situations, this act does not apply at all, but it does exempt several key obligations under the law. So so there are these different chapters in the law, right? And one of them is all of the obligations of data fiduciaries, which include, for any data processing activity, you have to make sure that there is some legal basis. You have to give notice, take consent. You have to retain data only as long as it's required for the purpose. You must implement organizational measures. You must maintain accuracy. All of these requirements are placed on data fiduciaries, but the law exempts this sort of specific situation is exempt from these requirements. You don't need to do all of this if you are processing data of foreign nationals under an offshore contract under a contract with an offshore entity. You also don't have to allow individuals to exercise their rights. That is also exempt. You're also exempt from that requirement. Again, the idea is that contract with the offshore entity will sort of govern all of this. That entity will also be subject to its own laws. For example, in the French example, GDPR applies to them, and through that, under the contract, there will be certain obligations that are passed on to you. So this law says at least these requirements you don't separately need to abide by, because some other law will sort of take care of it. And a critical one, of course, is that there is also a restriction in the law on cross-border data transfers. It is a far more sort of enabling provision than what we've seen in earlier versions of the law. But even then, there is somewhat of a restriction which says that you can transfer data to any country except to those countries that are notified by the central government. So tomorrow, if the government were to say that country X and Y, you can't transfer data, then generally data fiduciaries will not be able to transfer data to those countries, or data processors also will not be able to transfer data to those countries. But if you're operating under this exception, again, the foreign entity, foreign residence data, contract, those requirements are met, then these restrictions don't apply, because you've yourself gotten that data under some other contract, it's flown in from somewhere else, and it doesn't it's counterintuitive to say then that data must not traverse back, must not transfer back to that country. So this is also clear sort of exception that this restriction doesn't apply to you. So it is a fairly wide berth given, it is fairly wide in that these big main obligations don't apply, but it is also not a blanket one. There are a few provisions that still apply, and it is interesting. I think some market practice and some more probing is required here generally on what this might mean in practice in contracts. But the two big themes are, one, that the general provision is that DFs have to be responsible generally for overall compliance with the act. That still continues to apply. And also that all data fiduciaries have to implement reasonable security safeguards to prevent a data breach. This also continues to apply. So any sort of security measures that are required to be taken, that requirement continues to apply to this processing activity, this sort of, even when you're processing data under this kind of exception. And all of the data protection board's powers, these powers continue to apply. You're not entirely exempt from the application of these sort of powers. There aren't too many substantive obligations, but the data protection authority doesn't go out of the picture entirely. So that's really what the scope of the exception is. And I think we could perhaps, I'm mindful of the time, we can go into some of what this might mean in the Q&A as well. But just, I think one important piece here on what that contract framing suggests is that if you're, say, straying from that contract, as long as you're discharging, as long as you're performing within the limits of that contract, that you are eligible for that exception. But the moment you stray from that, I think then that and sort of the full force of the law then applies to you. That also means, I think one example is similarly taking that payroll, it's a simplistic example, but taking that sort of ahead, if you're conducting, that contract only allows you to process payrolls of that French parent company's employees, but say you start using some of that data for your own promotional marketing material, something else entirely. In those situations, first of all, you're traversing beyond the scope of that contract, so the exception doesn't apply. You may also be tripping from a pure play processor to a fiduciary, so the law in effect entirely sort of applies to you. And just what all of this means then for GCCs, what the practical impact of this is. First step would be to really identify what your role is. Are you acting as a data fiduciary for which activity are you acting as a data fiduciary? Where are you acting as a processor? Where are you acting as a joint fiduciary? And that will help set the tone for what all other obligations under the law apply to you. Then is to map out the data. Often this is also a starting point for compliance, where you understand what data is it that you're collecting, how you're using it, an overview, a visibility of that data, so you can keep a record and identify what you need to do with it. Evaluate your contracts with these offshore entities, identify the extent to which you can rely on that exception, ensure that the roles of both the parties are defined clearly, and also what really differences might be between this Indian law and sort of the offshore contracting parties laws as well. The DPA does sort of sit here. While there aren't too many substantive obligations that apply to you, I don't also think it's fair to say that it's a blank, like you just forget about this law entirely. I think this continues to be a stakeholder, which I see as a positive, because there is also the idea that, say, post Schrems to even when you're if you're contracting with EU based companies, or even your group companies are based in the EU and GDPR applies to them, even with standard contractual clauses, there are some additional safeguards that are required. So even in that evaluation, this might actually help to show that there is sort of this protection as well. I will stop there, I think, because I'm past time.
So thanks, Sreenidhi, and thanks. I think the last slide was particularly useful. So we just want to come to Nitin, and I think Nitin, we discussed yesterday about what exactly GCCs need to be doing, and I think one thing to take away from Sreenidhi's presentation is that the law actually does give a fairly wide berth to GCCs, and the obligations on them are not significant. Primarily, we're looking at reasonable security measures and just making sure your contracts are okay. Can we hear a little bit more from you on a couple of practical contexts in which they played out, particularly the one on mixed data sets, which we discussed?
Yeah, thanks, Varun, and thanks to nasscom for the invite. So very briefly, Varun, the point that I think we should all look into is Sreenidhi talked about two different types of data, right? Data which is collected within India, processed within India, the full effect of the law is going to be there. On the other hand, we have data which is getting collected outside India and then being brought here or processed here within India, right? Where a lot of the obligations of this law are not going to be applicable. And we have been talking about these two different data sets as different data sets, right? But if you look at a typical GCC setup, the likelihood of these data sets being there in a common database or in a common data store is going to be fairly high, right? I don't think we would have situations where we would have clear demarcation between Indian data, as we want to call it, and the non-Indian data, right? More likely than not, we are going to have data sets which will have both these types of data. And I think the question which, of course, arises from there is how are we going to handle this, right? How would the law apply to these kind of data sets? Um, and one of the things that we need to, I think there are a couple of things that we need to look into, right? One is the contractual part, which Sreenidhi also talked about very briefly. How are the roles and responsibilities of the parties defined in the contract, right? Who is defined as the controller, who is defined as the processor? Are you going outside that remit of what is defined as the roles and responsibilities of the controller and the processor, or the fiduciary and the processor, right? I think that's going to be very, very important to take into account. The second aspect is at a practical level, how are you going to ensure that the Indian data, of course, has the full force of the law? So you will still need to provide the notices, you will still need to provide the consent, and the non-Indian data, you will be exempt from some of those requirements, right? So I think both at a contractual level, how do we handle some of these requirements? We may need to go back and look at those contracts. If that clarity is not there, see how we can work on bringing in that clarity. And at a practical level, how are we going to ensure that data sets which are mixed in nature, we are still able to apply the law as it is going to be applicable. For Indian data sets, the full applicability, and for the non-Indian data sets, the partial applicability. So that's, I
So,
think those are the key things from a mixed data set perspective, which I think GCCs should take into account.
so Nitin, if I can just ask you, typically in GCC setup, from a business perspective, what you're looking at is probably data which is foreign data, right? Most of the data. So typically, uh, the data which is Indian data is likely to be either related to employee data or vendor data and so on and so forth. So it's unlikely to be customer data. So, so from that point of view, when you look at the 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 fact that the database is mixed, does it present a significant challenge from a compliance perspective, or because the compliance obligations are fairly clear? And so, given this as a starting point of my question, then the actual question is to say that as a typical GCC in India now, what is it that you should be doing sitting in this first week of October, or what you should have done till now, having seen the law getting enacted over the last couple of months, and so that people get a sense that okay, are they on the right track? So could you share from your own experience as to what are you doing, and that is something that people can relate to.
Thanks, Ashish. And that's a very valid question, right? I mean, yes, we have certain aspects of what is defined in the current act. We should be getting some additional clarity from the rules. But as we are in the first week of October, I think one of the key things that GCC should be doing is to start understanding their data inventory, the processing inventory, right? To ensure that we understand okay, what are the processes that we run? Where is this data coming from? Is it coming from Europe? Is it coming from the US? So that process/data inventory is going to be a good starting point, and that will give us an idea about which data is getting collected within India, which data is going to come from outside, which countries is it coming from, and so on and so forth. Right? So I think that inventory, typically what we call as a record of processing, would definitely be a good starting point, Ashish. And from there onwards, a lot of these other activities would start. The contractual part, which we briefly talked about, in terms of the protection that needs to be given, in terms of the rights which need to be exercised, and so on and so forth. So I think those would be next steps. Starting point would be a good inventory of what services the GCC is providing.
So thanks, Nitin, and I recognize that unfortunately you did have another engagement, so you'd only be available with us till 3. So I'd like to just make sure that we can use the last couple of minutes to pose one question to you that's appearing in the chat, that in the context of GCCs, there's, in the law, there's the concept of some transfer restrictions being put on transfer of data from India to outside. How would that apply to a GCC today? So, for example, if it's the data of an Indian employee of the GCC, how would that apply versus the foreign data that a GCC gets from outside India? So maybe we could just use the transfer restrictions to explain a little bit more about those two different roles that GCCs have to think about.
Yeah, I think if we look at the Indian data of the local entity, right, I think there the transfer restrictions would apply. So apart from the blacklisted countries, as we are calling them now, the Indian entity should be able to transfer data to countries which are not on the blacklist, right? So, and of course not transfer to the countries which are on the blacklist. So that is what is going to be applicable for the Indian data of the local entity. For the data which is coming from outside, I think, as again Sreenidhi explained, there is an exception. I forget the chapter name now, but there is an exception where the transfer restrictions would not apply, right? So that is how I would distinguish it between data which is originating within India. With the transfer can be done with some restrictions, but for the data which is coming from outside, the restrictions don't apply as such.
Great. So thanks, Nitin, and thank you for joining us as well. Vivek, I'm going to come to you, and perhaps we could have you just talk about this from a more sectoral context. It would be great to hear from you. We understand you've been working a lot with the financial sector GCCs. So over to you, Vivek, to cover that aspect.
Yeah, thank you, Varun, and thank you everyone for the opportunity. Okay, so I work very closely with the financial sector GCC, and I have been talking to most of our clients in terms of applicability. I think Sreenidhi mentioned it in her introductory talk. First point to start is you need to identify who you are, right? Are you a data processor? Are you a data fiduciary? Are you a joint data fiduciary? I think that needs to be understood first. In the GCC setup, there are different type of GCCs, right? And for example, when we work with GCCs, there are some back offices who are just acting as a support unit to their headquarters in US, UK, and other regions, where they're not actually offering any goods and services in India, right? They're largely processing the data of the US, maybe of EU, or some other data sets. So where they are foreign nationals, definitely that data will not apply, or maybe this particular law will not apply to them, right? The applicability, we have discussed about it, because that's more of a support function. But what more important, which I want to add on, which Nitin said and also Sreenidhi said, I think the clarity about securing those data which we are processing here, that's also very much important. And certain reasonable security control that needs to be applied, certain data instrument needs to be used. When data transfer happening from India to the globe and also happening from from other regions to India. So even if you consider any of the other laws out there in the globe, they always talk about certain data instruments and certain reasonable security measures that needs to be implemented to secure the confidentiality, integrity, and availability of data. So that's a very fundamental requirement of any lawmakers in the globe, right? And that's where all the GCCs are now, trying to classify themselves into the buckets where, what kind of role they are playing as part of the global capability center. But, and by and large, and, if I had to talk about our customers and with the client we talk to, there are three types of data, and there are very few GCCs who are offering goods and services. If I talk about a bank, only HSBC and some other few Citi and other banks who are offering the goods and services in India, where they're directly collecting the data of Indian in Indian territory per se, right? Where the law directly applies to them in terms of processing and ensuring the confidentiality, integrity, and availability. But apart from that, there are two other buckets, and I think those are very important. One is definitely the employment data, right? But under the legitimate use, certain data that data fiduciaries can process it, right? Because as part of their 7-8 legitimate processing of data, grounds of processing of data, GCs can process the data for employment. So certain data, but what data sets? I think that per certain rule will define, what extent that they can process the data of employees, right? They know, and what is the retention period for the employees? Most of the GC is asking question. Even if it is a legitimate use, how many of a time period that I would, retain the data even employee leaves the organization? So there are very granular questions. I think, I can talk for the hours. What are the questions which we face every day, and it's a day job for us. But but that's the second option. And third, which is more important, and that is a lot of the organizations which are worried about and concerned about, is that the third party data. There are a lot of service providers, whether it is a service, whether it is a service providers or whether it is a provision of any materialistic providers, right? They are also involved into this. And as per this particular act, there is no direct onus on the processor. It has to be taken between the contractual obligation, between the fiduciary and the processor. So a lot of GCCs now would like to see how they can make it more stringent, so that they are comply with this particular act, and there are no such a loopholes, right? What are the different elements that they can include? And I have been talking to a lot of global customers in Singapore and also in EU about the contractual obligations. And I think that's a very important aspect for the GCCs to look at it. Third party privacy risk management. And I think these are the one of the core and key areas that needs to be considered. One last point which I want to add from my experience, and I think there is definitely a scope of improvement, and it will signify when rules will come. I think we have gone to the reversal approach in terms of transferring the data from India to other territories. The GDPR talk about a trusted parties with whom we can share the data, and we are going other way around by identifying the negative list of the countries with whom we cannot share the data. But there are certain questions that are being asked by the GCCs that we are processing the Indian employee data, and say UK is being a whitelisted country by India, and we are sending the data to the UK data center, or maybe to AWS data center in UK. But what if the breach happens in that particular data center? Because see, breach notification is at center of everything, right? We are doing everything for maintaining the confidentiality, integrity, and availability of data. If breach happens in UK and UK or maybe some other region, and if that particular onus lies with the some other negative country, what happens if the data breach happened from there, right? What data instruments we are going to use? Who is going to be responsible for that? So I think there are a lot of questions, from that positive whitelisted country, the data is completely shifted to the negative country, which been identified by, our negative country approach. So there will be a lot of such questions will be evolving, and all the GCCs which I'm talking to, they are really gearing up for this, and I can say that they are really going into the minute efforts that we need to take to comply this particular act. And there are a lot of several questions that will get answered as we get a lot of clarity on the rules which government India will come up with. But I think that is what my perspective working with all the financial services client. There are many more questions at meniscus level, but happy to take any questions that you have. I'm just being cautious of time.
So thanks, Vivek. I think that was really useful, and especially because you, in your last point, talked about one of the biggest questions that's going on in the chat right now about how the law treats, the fact that many GCCs operate as part of global systems and they have global data centers. So I think one assurance that would be good to bring out would be, how does the law actually deal with, transfer restrictions under the main section? So I think there is no data localization by default in the law. Instead, you are allowing sectoral regulators to do that. So perhaps in the financial sector, the existing localization requirements continue to apply. The act doesn't let go of those, but the act itself doesn't stop and doesn't require data to be maintained in India. I think that's one important clarification to give out. One question which has come out in the chat is that the GDPR requires companies to have DPOs. what's the status in our law? And maybe Sreenidhi and Vivek, both of you can come in on this, just about how our law, when does our law actually require a DPO, and what's required if you don't have to put in a DPO, that entire distinction between significant and non-significant data fiduciaries. Sreenidhi, if you could just give us a quick sense of the law, and then Vivek, we could talk a little bit about what a DPO would actually have to do, or what an equivalent in a GCC would have to do. Yeah.
Sure, sure. So unlike the GDPR, the Indian law only requires significant data fiduciaries to appoint data protection officers. These DPOs have to be based in India, and they must be accountable to the to the organization. The DPO is sort of acting as the liaison between the regulator here and the entity, and also the user in some way. But yeah, it's not every data fiduciary that needs to appoint a DPO. It is only significant data fiduciaries. And how significant data fiduciaries will be are entities which are going to be notified. The government could say this class of entities which say has so many lakh registered users should be notified, are notified as significant data fiduciaries, and those are the threshold that comes in. I see there was a question on how significant it determined. There's a list of factors that the law sets out: volume and sensitivity of the data processed, risk to rights of individuals, so there are these parameters that have been set out there, risk to integrity, sovereignty of India. But I think the most commonly used one, which is slightly more, which is a little more practical and understandable also to us, is the user-based type threshold, that if you have so many lakh registered users, and that's the threshold that we've seen in the IT rules as well, intermediary guidelines for significant social media intermediaries. So likely that a similar threshold they'll apply. I'll pause so that Vivek can also come in on what the DPO will need to do.
Yeah.
So just before that, I think as far as GCCs are concerned, they are the data processors. So they don't need to have a DPO, right? But there's no doubt, right?
That's right. Only entities which are significant data fiduciaries, and those can only be data fiduciaries which are notified by the government.
Okay.
So I think that does help a lot with answering some of the questions in the chat on DPOs. I think another set of questions which is also common is, how does this law apply to the entity, the associate or the parent or the partner company that's located outside India? And maybe we can dig a little bit deeper into how exactly that would work vis-a-vis the GCC's relationship with that foreign entity. So how does the law apply to that foreign entity? Maybe Sreenidhi, Vivek, whoever wants to take that can definitely just jump in. So Sreenidhi, maybe you could just kick us off with the discussion around 8.1 first. Yeah.
Sure. So I think we discussed the exception, which is 17(1)(d), that if you're processing data under the contract, certain provisions will not apply, but certain provisions still continue to apply. The two key ones out of those are the one which says that the data fiduciary remains responsible overall for compliance, including actions taken by the data processors. And I think that does seem to suggest that that offshore entity, that data controller, is also still, to this effect at least, for this scope, is sort of subject to the requirements of the law, that they are responsible for ensuring that there are reasonable security measures at least that you're taking under this law. And there may be remedies as well, because the data protection board related provisions also continue to apply to that entity.
Yeah, so that was great. And Vivek, I think we would look to you to just provide a little bit more sense of what are these reasonable security measures exactly, right? So what does this actually mean in a practical context? Like, what are the different kinds of things that GCCs need to be thinking about?
Yeah, Varun, I think that's a good question, and frequently asked by many others. When you talk about the data transfers, within the countries, right? They always talk about certain data instruments and reasonable security controls. For example, if I'm transferring the data from one location to another location, I need to ensure the data in, how do I encrypt that data, when it is in a transit? How I encrypt the data when it is at rest? How I ensure that it is integral when it is in the motion, right? So as per IT Act, there are definitely certain reasonable security controls are given, which could be used to ensure the confidentiality, integrity, and availability of the data. For example, if you are doing a certain data transfer, between the two locations, you have to have certain encryption TLS mechanism or a certain channel that we will ensure that my data is very secure and safeguard, right? For example, there are other regulations like you have to use a VPN for ensuring the confidentiality of the data. So all these encryption, utilization of technologies, and we call it as a privacy enhancing technologies, which will be playing a more role in terms of ensuring the safeguard of the data, when it is getting transferred in and out. So those reasonable security controls will be there. There are NIST privacy framework which is already out. I think most of the organizations is referring to those frameworks, in terms of what are those reasonable security controls. But one thing which I want to add here, Varun, as my a key remark here is that privacy has to go hand in hand with the cyber security. Those the security controls which will ensure that my data is not mishandled. It is not accidentally even leaked to any other party which shouldn't be leaked to. So cybersecurity and privacy must go in hand, and that's why this act particularly says that even though this act talks about the privacy and data protection, all other regulatory bodies in India or maybe all other regulators in the globe, their basic cybersecurity hygiene and security control implementation will remain there. And even the local regulators, or say RBI, IRDI, and SEBI, they have a certain cybersecurity and data protection framework. So this particular act will not supersede any of those requirements, which is prescribed by the regulators. So this is how we ensure that we connect the dot to ensure the reasonable security control over the data.
I'd just like to also just pick up from that and perhaps zoom up. So obviously, sectoral regulations will continue to apply as they already do because of the way that the sectoral regulations work. I think one.
Varun, even I think it's important to clarify. Even when you think of sectoral regulator, only if you are a regulated entity in India will the sectoral regulator apply. So if you are just a GCC, even though you might be a financial GCC, but if you are a GCC for a US regulated entity, then RBI regulations will not apply on you. So from that point Absolutely. Of view, I think therefore you don't have to worry about sectoral regulation in India in terms of what they might do in terms of data processing. I think for GCCs, the lens is very simple. One thing is that your contract with the parent company is very important. And I think that's been highlighted by our panelists. And then within that contract, you already have security safeguards built in as part of your contractual obligation. So now that de facto becomes a baseline standard for you, even under this law. Now, beyond this, I think the next step is for us to see what is the reasonable security safeguard kind of standards or measures which might come under the rules. And then if those are stringent than what you already have in the contract, then you will need to provide for that, because that is the only area where there is in a larger sense the scope for facing penal provisions. And that's what in some ways adds trust to the fact that with this law coming in, there is going to be much more comfort for the data to be processed in India, even through GCCs, because now there is a backing of the law. Beyond this, I think the larger point is about that you have Indian facing engagement in terms of employees, in terms of vendors. That is where you need to then apply the full face of the law. But that's a much smaller context. And you are unlikely to be a significant data fiduciary from just that lens. That's our understanding. And also, I think the thing about the cross-border data flows is that even though sectoral regulators in India might have a requirement of local storage, then again, from a GCC lens, you should not have to worry about that, because then again, you don't have to deal with those regulations. As far as negative list, even if there is a negative listing, that again, I think Sreenidhi clarified that because if you're processing a foreign customer data, from that point of view, that's not going to apply to you. So worrying about cross-border data flow shouldn't be a problem. I think one interesting thing which at least I got as a question was that if you have transferred the data somewhere else and there is a breach, then how does it work from your overall risk management perspective? Because clearly then obviously if GDPR is applying to your process, then that law may continue to apply. In my understanding, and that's why Sreenidhi and Vivek, you can correct me if I'm wrong, as far as the Indian law is concerned, if the breach is happening somewhere else, then and it pertains to data of foreigners, then Indian law wouldn't apply. And then you, as far as the Indian law is concerned, the only and I'm not talking about the data protection law, but more generally, it then boils down to your contractual arrangement with your foreign parties, and under the general contract law and so on and so forth, there might be some recourse, but that's something I thought I'll double confirm, maybe first with Sreenidhi and then Vivek, if you have to add.
Yeah, I think that's fair. So essentially under the contract, you've been given the data under the contract. It's only foreign residence data. So the law applies to you only very narrowly. Now, if you've transferred that data somewhere else, then your obligations are only what is flowing through in the contract. If your data controller fiduciary has told you under the contract, I think that's what will flow to you. And then you're responsible if you're transferring it to a sub vendor elsewhere, then mirror those like back-to-back arrangements in the agreements with your sub vendor, and also of course making sure that in your original contract you had the right to appoint that sub vendor and transfer data. Again, here I'm talking about a scenario where we're transferring data to say a sub processor elsewhere, and the data is hosted elsewhere.
Okay, just one more follow-up question. Sorry, Varun. So, see, a lot of the GCCs anyway are obligated under the GDPR when they are looking at European data, and the controllers, impose on them conditions through the standard contractual clauses. Now, that entire framework, when this law comes in, doesn't change, right? That just continues as it is, and GCCs don't have to worry about having to go back to the data controllers because of this law. Is that a fair statement? Again, just a quick yes or no.
Yeah, I think that's fair. That it's the DPA, SCC, you will already have those. Those are flowing from the GDPR. Those you will have to anyway sort of abide by.
So and that's,
I think the one sort of the one change is if under Indian law, the government says that reasonable security measures may mean something over and beyond what say SCCs, DPAs are requiring you to do. I think that to that extent, because 8.5 applies, I think that there is some space for that additional sort of comfort. Any sort of restrictions there.
And that's exactly, I think, if we had to just zoom back and look at one key message, right? So GCCs could be dealing with Indian employee data of their own employees, for which they would be fiduciaries. And we actually held a webinar just yesterday, which will be up on YouTube shortly, about just generally how you deal with personal data as an employer, the personal data of your employees. So do check that out. It will be available on social media. I think that the difference in the law is between when you're dealing with the data of Indians and when you're dealing with the data of non-Indians. When you're dealing with the data of non-Indians, the exemptions starts to apply, and your obligations become largely just ensuring that you and your fiduciary clarify all your obligations in your contract, and you have reasonable security measures in place to prevent personal data breaches. I just wanted to highlight one question over here that would be important, I think, to bring out, that the definition of a personal data breach in our law is a bit wider and a bit more different as compared to what people familiar with the GDPR may know a data breach as. So Sreenidhi, maybe we could have you come in on this, and Vivek, we'd also like you to come in and just speak a little bit more in the context of what unauthorized processing under our law means. So Sreenidhi, just run us through the law, and then Vivek, we can have you talk about the practical side of it.
Yeah, you're absolutely right. Varun, that the definition of breach is wider because it doesn't just include disclosure, alteration, anything that impacts confidentiality, integrity, availability of data, which is standard, which we're familiar with around the world, but it also includes any unauthorized processing of personal data. And this is taken to mean if you process data you're doing something which is not provided for, not envisaged under the scope of the law. So if you've taken data or collected data for some purpose, but you use it for something else, even those instances are interpreted, understood as breach under this law.
Yeah, and so Vivek, I think the important thing to bring out here is that means that as the data processor here in India, if you have to do reasonable security measures to prevent personal data breach, that means not only thinking about security, but it also means thinking about privacy and making sure you're sticking to the instructions that come from the foreign entity and from the foreign data controller, let's say under the GDPR. So can we hear from you, Vivek, about just generally how somebody can ensure that the GDPR level measures that you're currently implementing
just
continue to flow into the
point
law?
Yeah. So absolutely, I think going back to the definition of a personal data breach, and I think it completely call out any unauthorized processing of a personal data, whether it is accidental disclosure, whether it is acquisition, whether it is a sharing, use, alteration, destruction, loss of access, all of these terminologies collectively called as a personal data breach. So even if it is accidental acquisition, alteration, all of those which will impact the confidentiality, integrity, and availability, that's the the breach of the personal data. So that particular act clearly calls out in its in its clauses. Secondly, your question about data processors are being processing the data in on behalf of data fiduciaries, right? So all those necessary the security measures and also about the privacy measures that definitely needs to be implemented to ensure that there is no erasure, there is no accidental disclosure of a personal data breach, and that will be immediately qualified as a personal data breach. However, this definition, as you mentioned and Sreenidhi also called out, it's very vague and very open as of now. Okay, but one thing which from data processor point of view is very much important, and I think the rules will tell what contractual obligation between data fiduciaries and processor can take place to ensure data processor also processing and ensuring the security and privacy with the same level of maturity that fiduciary will do it, right? And all of those obligations may gonna come through the different obligations that they will put into the contractual terms, right? So I think, and as mentioned, as of now, it is not referring to any framework or any certain guidelines and standards. But if you talk about the financial sector, there are already certain standards like PCI DSS, which talks about the very stringent regulation and compliance to secure and safeguard the data. Or maybe if you talk about some of the NIST framework are being implemented by some of the GCCs at headquarters. All of those things which are already there, and it's just for GCCs to ensure those are implemented correctly when the processor are going to process the data on their behalf.
I think one question. Sorry, Vivek.
One last point which I want to add, and that that Nitin mentioned, most of the GCCs today, they have a big problem to solve. Is that most of their data sets and most of their most of the critical data of their employees and third parties, it is centrally hosted, right? And usually not necessary to be in India. That can be in their headquarters, that can be in some other geography and some other location, right? So that's more worrying and most the complex structure that GCC needs to be.
So I think Vivek, the screen froze, but he was bringing up a point that is appearing in the chat a lot about
data as Indian employee data or in rules. So all those things will, yeah.
So maybe I think one interesting point to what just Vivek said that got discussed in the yesterday's webinar is that, see, when you're thinking about your employment data or employee data in that anyway, for the purposes of employment, the law allows you to process the data without having to take consent. So from that perspective, I think even if, let's say, you're storing an employee data on a central server at a location which is outside India, and that's your current practice, and you want to continue with that practice, you don't really have to go back to employees to take a consent for doing that, because it is for the purpose of employment. So from a business disruption point of view, if you look at this particular law and you look at your data protection compliances, then I think the key thing is around ensuring that you are doing all the processing as per the contract. And second is that you make sure that your security safeguards are really up there and can take in anything which the government brings in as additional points. And I think if you manage these two well, then at least the understanding at the stage is then as a GCC, you should be comfortable in the compliances with the law. Again, I'll just quickly try to validate that with Sreenidhi and Vivek. Is that more or less in a simple terms, is that a correct understanding?
So your own employee, we're talking about a situation where the GCC may be acting as a fiduciary.
That's right. That's right.
Yeah. So just one sort of difference there I'd point out is that while fair, legitimate use, you don't need consent because it is recognized as a legitimate use if you're processing data for the purpose of employment. But I mean, all other obligations do apply. So you do have to implement organizational technical measures. You do have to, if there's a breach, you do have to notify the board with respect to employees' data also. But you're right, of course, consent and even individual rights are not applicable to when it's an employee situation. But yeah, just that all other obligations would anyway would still apply. I think that's something to just be mindful of. In fact, for a lot of our clients, we've also just been even thinking through the employment piece. I think it still makes sense to map out what data you're collecting about employees. And whether you need that or not, is it necessary for the purpose of employment? It is a wide framing, but there are a few things that are called out there specifically. And, if there is something which is very, very unrelated to the purpose of employment, I don't know, I mean, anything which is highly sensitive, very distinct, I think it still makes sense to evaluate whether you actually need that or not, and whether you need to make it some kind of a distinct optional collection of data. I think just as good practice, I think that's also necessary here.
Yeah, I think that resonates very well with the discussion which we have had till now, because I think, and this is irrespective of whether you are a GCC or a data fiduciary in India, is that you definitely need to go back and look at what is the data that you are collecting and why are you collecting it and why are you even storing it, because even storing is processing. And then the first thing to do is to figure out if there are data which is not really required and then probably stop processing that altogether. I think that probably is an exercise which as a GCC you would be doing probably because that's something as part of the global regulations you would be anyway required to. But it's good to know that even in the case of data protection law in India, you must do for sure. Varun, we are towards the end of time. And if you have some last minute notes or any final question. You're on mute.
Just a last minute note actually to just conclude. So we noticed a lot of questions in the act that questions in the chat that I think would just get resolved by virtue of just having a read through of the act as well. The act is simple. There's only about 20 sections which really are obligations on fiduciaries. So when you are a fiduciary, because you're dealing with Indian employee data, the obligations aren't actually that detailed, and a lot of the basic questions around what you have to report, what is the rights, etc., how do you use when do you need consent, etc., gets clarified out from the text of the act itself. We've also run 2 webinars which will be available. One of them is already up on YouTube. One of them will be up on YouTube along with this one shortly, where I think a lot of the questions around consent and around employment will get answered through those as well. So this session was about talking about GCCs and the foreign data exemption. So we hope that information has been useful and we've managed to clarify those questions. And with that, I'd like to close. Thank you so much for joining us. This has been the third webinar that we've held, and we look forward to hearing from you over email if there are any further questions in chat. Just to quickly conclude, Priyanshi and I are in the NASSCOM public policy team, and we work on data protection, and Ashish heads the public policy team at NASSCOM. Thank you, everyone. Thank you all for joining. Thank you, Sreenidhi and Vivek, for joining us as well.
Thanks,
Thank you.
Sreenidhi. Thanks, Vivek.
Thank you. Thanks for having us. Bye-bye.
Okay.